here, Judge Vonda, and the owner of Vonda's Law.
And I am attorney Carla Marable, a practicing criminal defense attorney, state of Michigan.
And together, we are the Legal Divas of Michigan.
What's going on, Carla?
How you doing today?
Feeling wonderful. I want to start out. I want to say, and I know you're going to chime in, thank you for all of the viewers. 1 week, over 10,000 views on the podcast.
Thank you.
We appreciate that. Let's get into it. PDiddy. 34 days, multiple witnesses on the prosecution, nobody on the defense. How you calling this?
Well, one of the things is they only the jury asked for 2 people testimony.
Why?
Out of all the witnesses.
And let me just say this. Cassie Ventura, 2016, when she was assaulted, and a sex worker at the Essex Hotel.
Correct.
They requested that transcript. Okay, the readback. Just as a side, as a retired judge, I never gave it. And I never gave it because it would take days to produce. And also it becomes trial by transcript. What I'm thinking, I want to see it written. Then you want to see the transcript of somebody else. And before you know it, it's all his transcript. So you say, or at least I would, rely on your collective memories. This is a young judge, a new judge. His way is a lot different. There was a request. Then ultimately, they indicated that they had reached a verdict on 4 of the 5 charges, the racketeering being the one that they're having problems with. Your take, you say the reason they requested those 2 people is because what?
I think that they requested those 2 people because out of all the witnesses, those are the only 2 people that they felt was credible. They felt that they were credible or believable or something about those 2 witnesses. One of the jurors wants to double check with to see if it fits the criteria. But out of 34 witnesses, and they only asked for the readback for 2, those are the 2 witnesses that the judge...
Some of them people were embellishing. It was hard for me to even believe a lot of that testimony. Some of it kind of got kind of weird. And here's the situation. Am I right? If they looking at me for something, and each of these people got use immunity, and maybe it's something I know coming down the pipeway, I may be more reluctant to testify according to what you want so I can get a dismissal on my case.
Correct.
You've seen it with co-defendants at the state level. Do you see people under oath testifying so that it would be favorable for the prosecution to get a break for them?
You see it all the time. You see it in state cases. You see it in federal cases. In this particular case, I believe that Jane, I believe that some of the other sex workers definitely embellish, right? Mm-hmm. And one of the reasons why I think...
Embellish mean they wasn't being honest. But let me ask a question. Raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, none but the truth, so help you God? There's nothing magical when they take the witness seat. If they lie, it's not going to say, bah, bah. Nothing happens. They can look you dead in the eye and say whatever it is. And so many times, even in state cases, we'll later find out after, unfortunately, a conviction that there were people that lied. They were not truthful. And many times they did it so that they could get some type of break with the government. When people are interviewed, okay, and they'll say, potentially, we know you got a dope case, but we ain't interested in that. We want to know X, Y, Z, A, B, C. Now, if I know that, and they give me use immunity for this trial, that doesn't necessarily preclude them from trying to look at me for something else. So many times, and I'm going to tell you who I would find that with. You would find it a lot. And let's talk about it. Jailhouse snitches. Ooh, Galuka. I ain't getting no benefit from this, and they were dangerous. They would befriend potential people going to trial. They would look at their discovery, and they would bait them into saying that they made a statement or a confession or something. They got enough, sent a kite, that's a letter, to the prosecution or the police. I got some information. They get pulled out, blah, 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 ABC. Did you ever find that in your practice?
It happens all the time. You will have somebody on a case. They're trying to get out of the case. And
their own case.
They're trying to get out of their own case. And they send a letter to the prosecutor, say, so-and-so told me he did it and how he did it and this and that. And many times the prosecutor will put them on. And sometimes they are believable.
Do you tell your defendants, your clients, to safeguard their discovery?
I normally don't give my clients their discovery if they're in jail. I will take it to the jail. I will go over it. Now, they are the clients, so I work for them, but I would tell them, it's not really good for you to have your discovery. And
they'll take 4 things out of the discovery, okay? 4 things, okay? And put it right back, and then they'll indicate, and it seems to be factual. Correct. And it's many times because they've read their discovery.
Exactly. That's why, I always tell clients, you retain me, I work for you. If you need your discovery, call me. I come and we'll go over it. But for the most part, I don't think it's a good idea to leave your discovery with your client.
Absolutely, unequivocally not. And many times when I would see it, unfortunately, would be when the case broke down and that person went to prison and there was a motion for a new trial. And then we found out this person was not being honest, under oath. They were not doing that. And so I think you're right that those are the things that they looked at. And let's talk about it. I have found that the more good looking you are, the more believable you are. The more you have credentials, the more people will believe you. We want to believe that good looking people